motion to strike. When they cited the net worth stipulation, which I just cited to you, that said it's solely for the purposes of the punitive damages phase of the trial and for no other purpose, here's how they describe it. And we bolded this at the top paragraph of page 16. Open parent, net worth stipulation entered into for purposes of the case. Now, you don't think that's them trying to pull one over on this court and on us? That's literally not what it says. I mean, I don't know how you do that unless you're trying to work a fraud on this court, unless you're trying to work something that isn't supported by the facts. Net worth stipulation entered into for purposes of this case. It wasn't entered into for purposes of the case. It was entered into for a specific phase, for a specific reason, and for no other purpose. I don't think Mr. Brannick understood what they did in their preventative. They used it to challenge the compensatory damages expert we put on. It wasn't about what they argued to the jury. We entered into it so they could tell the jury what the net worth was. Now they've come back and said, oh, but look, their expert, their forensic economist doesn't comport with the stipulation that was entered into for punitive damages and no other purpose. But look at that language, Judge, because we would submit to you that that's exactly what Mr. Brannick just argued they weren't trying to do, is exactly what they tried to do with the stip. Okay? Thank you, Judge.
Thank you. So, strike are generally disfavored and very drastic. Court's going to deny the motion to strike, but I do also recognize some of that was in the defense to the other motion, so you don't have to repeat some of those arguments.
Mr. Vote's going to handle that part of it. We understand that, Judge.
Okay, thank you. So, would the defense at this time like to do the motion for judgment notwithstanding the verdict, or would you rather just jump to the one that we're sort of already in?
I think probably, Your Honor, logically it makes sense to do the JMG first, if that's all right, Your Honor.
That's fine. Mr. St. Pierre.
Thank you, Your Honor. So, Your Honor, as you know, we have moved for JMV on a number of grounds. I'm happy to address anything Your Honor would like me to address or answer any questions, but I'm not going to go through, and you'll be happy about this part at least, I'm not going to go through each of the grounds. I just want to focus on 4 pieces of this, Your Honor. So the first piece is the public concern piece, which is a part of that I'll explain. The second piece is the right of publicity piece, in particular, the commercial purpose prong of that tort. The third piece is entitlement to punitive damages. And the fourth piece is personal liability for Nick Jenkins. And I think if opposing counsel doesn't object, and you don't object, Your Honor, I think it makes sense to sort of do it one by one instead of having me talk for a long time. And if that makes sense, Your Honor.
That's fine.
Okay, thank you.
Who's on you about questions? Mr. President?
Yes, Your Honor.
Thank you. Is that fine with you?
That's fine. So, Your Honor, on the public concern issue, you're very familiar with this phase in the case with our basic story about public concern, so I won't belabor that. I want to just focus on one issue, which I think is what they focus on in their opposition, and that is the issue of what to do about the prior DCA opinion in this case, the temporary injunction. As you know, it's our view that the DCA's prior ruling that the challenge publication relates to a matter of public concern compels reaching the same result here at the merit stage. And we think that's true whether that's understood as a law of the case decision or simply binding appellate precedent that you need to apply to the facts of this case, which, by the way, are almost exactly the facts of that case because it's the same case. Now that we're in the post-trial motion phase, plaintiff has sort of fully articulated plaintiff's theory for why the second DCA's opinion can be disregarded. And that's what I want to focus on. I want to address that theory. The theory, as I understand it, basically has 2 steps. The first step is to say that A.J. Valeri's testimony, which conceivably was not before the DCA, the temporary injunction phase, that testimony changes the game in a way that makes that prior decision inapplicable. It gets it out of the game altogether. It's gone. The second step is basically say that now that the only Florida case that we have that addresses the public concern issue in the celebrity sex tape context, now that that case is gone, we can go back to relying on the cases we talked about before the second DCA opinion, the Michaels 1 case, the Topolini case, the Go case, all these cases we know so well from the time we spent together in this case. It's our position, Your Honor, that both steps in that argument are wrong. I want to talk first about Valeria's testimony, and I want to make 2 points there. First, I think plaintiff has mischaracterized Valeria's testimony. It's just not true that there's no connection between the grounds on which the DCA based its public concern determination and Mr. Valeria's testimony about what he was trying to do when he drafted the publication question. I want to quote from the DCA's temporary injunction decision, right? The heart of that ruling was as follows. This is from page 1201. It is clear that as a result of the public controversy surrounding the affair and the sex tape, exacerbated in part by Mr. Bland himself, the report and the related video excerpts address matters of public concern. That's the heart of that decision, page 1201. Under that ruling, the Gawker publication, including the video excerpts that were issued in trial, relate to a matter of public concern because they relate to this ongoing public discussion about the sex tape to which Mr. Balea contributed in part. There were other things that DCA talked about, right? They talked about Mr. Balea's autobiography. I think they talked about some other things, the TMZ appearance, that they thought formed the relevant context for evaluating the publication, Your Honor. But the heart of it was there was an ongoing public discussion and Mr. Balea participated in it. That understanding of the grounds for holding that the publication related to a matter of public concern is consistent, perfectly consistent with Agent Valeria's testimony. He testified at trial, this is not disputed, that he was aware of those prior reports about the sex tape. He had read reports in March 2012 from TMZ. He had seen the pictures of the jury in April 2012. And he testified about this as well. He explicitly referenced those prior discussions in the text of his commentary. There were hyperlinks to TMZ, to the jury, and to some other places. None of that's disputed. Mr. Valera also testified that upon watching the tape, he was struck by the fact that Bubba Clem appeared to consent to the encounter, and he testified that he highlighted that in his written opinion, or written decision, and it's highlighted in the video excerpts. And that was a new fact that Gawker confirmed, right? Gawker advanced the conversation about the sex tape, and that's what the DCA is focusing on, the conversation about the sex tape. Gawker advanced that by adding these facts. If you look at what happens after Gawker publishes, you get these new reports that are jumping off of that new fact. Mr. Blake goes on Howard Stern, he confirms various things. Bubba Clem goes on the radio show, he confirms new things. The ball is advanced about the sex tape discussion that pre-existed the Gawker publication. So if you look at the heart of the DCA opinion, you look at the heart of Mr. Blair's testimony, they line up completely. Now, I'll concede to you that Mr. Delaire, when he talked about his personal interest in the publication, talked about other things too. He said, as a Hulk Hogan fan growing up, it was very weird to see the sex tape. That made me think about celebrity sex tapes in general. I was interested in that. He talked about a lot of things that interested him. But he was certainly, in thinking about how he was contributing to the public discussion, he was exactly in sync with what the DCA eventually held. That's the first point. There's not this disconnect between the testimony and the DCA opinion. The second point is, it doesn't matter. The public concern analysis is, at its core, fundamentally objective. What makes a publication relate to a matter of public concern does not rise and fall with the specific things the author of the publication happened to be focused on. The analysis, we've been through this for 3 years, right? The analysis turns on the content of the speech in question, evaluated against the context in which the public received that speech. And that context includes facts other people know about the subject matter of the publication. Facts that they then use, whatever the publication says to advance the discussion.